Buddy. Hello, everyone. My name is Jeremy Herman. I am an employment lawyer at Samfiru Tumarkin, LLP. I'm located in Toronto, Ontario. As many of you know, we do multiple of these employment law Q&A sessions every week so that you have an opportunity to ask your questions, to understand your workplace rights, and we're here to help you understand that. And we have colleagues in Ontario, British Columbia, and Alberta that do these sessions. And I'm in Toronto, Ontario, so I'll be answering your questions related to your Ontario employment law questions. Now, we have helped thousands of individuals understand their workplace rights, negotiate severance packages, and so I'm here today to answer your questions so that you can get an opportunity to understand your rights. Now, before I get your questions, I want to move on to a hot topic right now, which is something called IDEL. And that is the infectious disease emergency leave. So if you don't know, on March 19th, 2020, the Ontario government implemented something called the infectious disease emergency leave, IDEL. And during the IDEL period, non-unionized employees whose hours were reduced or their wages were cut as a result of COVID-19 were put on this job-protected leave called IDEL. IDEL is now over, and it ended on July 30th of 2022, so just a few days ago. And even before IDEL was over, you should understand that we've helped thousands of individuals pursue their severance rights, even though they were placed on this IDEL, this job protected leave. But now that IDEL is over, it is particularly important that you contact us immediately so that you can understand whether you're entitled to severance. You likely are entitled to severance pay if you are not recalled back to work. And you can contact us at employmentlawyer.ca. And you can email us at help@employmentlawyer.ca. And so whether you have been recalled back to work or not, it is particularly important that you contact us to figure out whether you're entitled to severance, because you likely are. And this applies to you even if you have moved on to other employment. So if you have a new job, if you didn't wait around for over 2 years to hear from your employer, you still likely are entitled to severance pay. So please contact us, and we can assist you. Now, I have a question here that I will answer, and it is from Luco on YouTube. And Luco says, I am non-vaxxed, non-union. In June, I was called back to work. In September, vax requirement suspended. Can I claim back pay and on what conditions? So Luco, if I understand your question directly or properly, you were recalled back to work. The vaccination requirement is gone, and you want to know if you can get back pay. You might be able to get back pay. You should definitely contact us to figure that out. It will depend on your particular circumstances, whether you have actually returned to work or not. I'm not sure if you've actually returned, but your employer was not allowed to put you on a leave of absence related to the vaccination requirement. So you are entitled to severance pay, and whether or not you've gone back to work, you might be entitled to back pay as well. So please contact us at help@employmentlawyer.ca. I hope that answers your question, Luco. And Luco has a follow-up question. HR says the vax policy may be reinstated. If they put me on a leave of absence again, can I claim severance then, or I won't be entitled to if I didn't claim it last time? That's a very good question, Luco. If you are placed on a leave of absence absence again, you can claim that the leave of absence is a constructive dismissal, in which case you were likely entitled to severance pay. The fact that you did not claim that last time might have an impact on whether you will be successful at claiming that you have been constructively dismissed, but it is most likely still worth doing so because every situation is different. As we know, COVID-19 and vaccination policies are always evolving. So it's worthwhile to contact us. You can contact me directly, or you can contact us at help@employmentlawyer.ca, and we can figure out whether you are entitled to severance pay. You most likely are. So please contact us. And I hope that answers your follow-up question, Luco. Okay, and so as I wait for more questions to roll in, I'm going to go back to the IDEL piece. And I just want to lastly mention that if you refuse to go back to work and you're being recalled, then it could be considered a resignation of your employment. But it depends on the position that they're offering you. If your employer is offering you a completely different position, then you should absolutely contact us, because that, again, might be considered a constructive dismissal. And so you should figure out whether you're entitled to severance pay. So please contact us in that event. Now I have another question from Lana. And Lana says, my husband was recently laid off from his position due to a work shortage, but he was diagnosed with MS shortly before this happened. Is there anything he can do about this? They posted his position on Indeed. So if your husband was terminated or laid off, he is absolutely entitled to severance pay. Now, if he was diagnosed with MS, as you said, Lana, and the employer was aware of that prior to laying him off, your husband might, in fact, be entitled to more than just severance pay. There might be a very viable human rights claim here. And so you should absolutely contact us because, again, your employer might have terminated your husband for reasons related to discrimination, and that would be very problematic. And so we'd be looking at more than just severance pay for the fact that he was laid off, but potentially also human rights damages if the employer laid off your husband for any reason related to his diagnosis of MS. So please contact us. Again, help@employmentlawyer.ca. Don't hesitate and don't hold out as well. Okay. I have a question from Martin Knight. Martin asks, what is the threshold to determine if an employer cannot fulfill a request for accommodation? I was injured on the job and requested modified duties, but my employer has been fighting me on it. So, Martin, if I understand your question directly, your employer has to accommodate you up until the point of undue hardship. So the Human Rights Code talks about this threshold of undue hardship, and that's a very high threshold. It means that they have to do almost everything in their power to accommodate you related to your injury on the job. And so your employer should not be fighting you on that. And if they are, then there's an issue there. And you should definitely also contact us to figure out whether your employer is properly accommodating you. It sounds like they are not. And you might also have human rights damages here. So please don't hesitate to reach out and to contact us with your more particular circumstances. I'd be happy to help you out. Any of my colleagues would be as well. So Martin, I hope that answers your question. I have a question from username JC200 4X. And they ask, are the employment regulations of the Northern Territory similar to those of the province, or are they much different? So the regulations in the provinces and territories do differ. Sometimes they're similar often they're similar, I should say, with respect to severance pay, but there are differences. What is very similar is your severance pay according to the common law. And without getting into the nuances too deeply, you should know that the common law would allow for an employee who's terminated or laid off to get as much as 24 months of pay. That applies everywhere in Canada, except for perhaps Quebec. And so you should definitely contact us and figure out whether you're entitled to severance pay if you've been terminated or laid off. Again, you can see it on the screen there, www.employmentlawyer.ca. Okay, more questions rolling in. I'm happy to see so many rolling in. We have a question from Carrie. They asked, my boss has told us multiple times that we are going to be working from home going forward, but they have started to recall us back to the office. I moved and cannot make the trip. What can I do? Good question. And it's a very relevant question, Carrie, because as we know, when COVID hit, many people started working from home. Many people still do work from home, but many people are being recalled back to the office. And so if your employer has allowed you to work from home and now they are recalling you, that is generally legal. Your employer is allowed to ask you to work back at the office. Now, it will depend on whether how your employer has described in the past your ability to work from home. If they made it sound permanent, then that would be considered a permanent change to your employment. And it could potentially be a constructive dismissal if they're making you come back to the office. But again, it really would depend on the particular circumstances of your case. So please contact us. Let me help you out, or any one of my colleagues, to figure out whether in your particular circumstances, the fact that you're being recalled back to the office, whether that is an issue, whether it's legal, and whether you're entitled to severance pay if you don't go back to the office. So, Carrie, I hope that sufficiently answers your question. So I have another question from username Mrs. Nuffles 10. And they asked, are you able to help with human rights claims that may go through the Ontario human rights process, even if the employee is unionized? I'm talking about a claim outside the grievance process. So it will depend. Generally, our firm can only assist individuals who are non-unionized. As you know, there are particular grievance procedures for unionized employees, and so you typically have to go through that process. It might be worth contacting us to figure out whether we can help you in any way, but know that generally speaking, we cannot assist unionized employees. But contact us and see if there might be an exception based on your particular circumstance. And again, you can reach us at help@employmentlawyer.ca. Okay, and so we have another question from Elise on Facebook. And they ask, what does it take to prove a wrongful dismissal? My employer has made allegations against me and let me go without severance. It was all untrue, though. So Elise, a wrongful dismissal, what that really means, and many people may not understand this, and that's totally understandable, but what a wrongful dismissal means is that you were terminated without severance pay when you are entitled to severance pay. And so in Ontario, your employer is allowed to terminate you for any reason, as long as it is not a discriminatory reason, so long as they pay you the fair and reasonable amount of severance pay, which often does not happen. And so if your employer is terminating you without severance pay, then they're likely terminating you for something called cause. Generally, your employers may do that even though there is not actually cause to terminate your employment. And so you should definitely contact us. We've helped, I don't know how many thousands of people who have been terminated without severance pay for cause. And it's not true at all. The allegations might be untrue. And even if they are true, it doesn't mean your employer can let you go without severance pay. So Elise, I hope that answers your question. You're likely entitled to severance pay. Definitely contact us and we can help you determine that definitively. Okay, I got another question from Ali Sheikh. And Ali asks, our company has merged with a sister business unit from the States. My job duties have become extremely light to the point where I'm only working a couple hours a day. I feel I lost my seniority too. Can this be considered a constructive dismissal? Ali, it definitely can be considered a constructive dismissal. Your employer cannot implement any substantial changes to the terms of your employment, without your consent, I should add. And whether those changes are related to your duties, to a reduction in your pay, your hours of work, your job location, all of these factors, if there are substantial changes, then that is certainly a constructive dismissal. And we should help you out to figure that out, to get you the severance pay you deserve. And it also will depend on whether there's an employment agreement in place and what your employment agreement says, Ali. So, some employment agreements do allow for certain changes to your employment to occur without it being considered a constructive dismissal. And so let us take a look at that employment agreement that you might have and to figure out what we can do for you. So please contact us at help@employmentlawyer.ca. Okay, I have another question from Archie. And Archie asks, my employer has asked me to sign a new contract and offered a $200 incentive. The contract would place me back on probation and will also remove my 15-year seniority. Do I have to sign? You do not have to sign, and you likely should not sign such a contract, Archie. Employers do try to do this. It's frankly speaking quite sneaky and manipulative, and you should definitely reach out to us because you should not sign any new agreement without an employment lawyer such as one at our firm looking it over. And especially that is the case in your circumstances, Archie, if you're going to be placed on probation again, if your 15-year seniority, which is a very, very substantial seniority, will be removed. So don't sign that without us looking it over, and you can likely consider that a termination of your employment. Now, I just want to add that we have a very useful tool, and it's called the Pocket Employment Lawyer, and you can access that tool on our website by going to www.pocketemploymentlawyer.ca. And it's an incredibly useful tool. And like I said, you get, depending on each of your particular circumstances, you might be owed up to 24 months of compensation of severance. And the Pocket Employment Lawyer will help you determine what you're owed. It's a very easy tool. It's very user-friendly. And it's free. So please check that out, pocketemploymentlawyer.ca. Okay, we have another question from Sheena. And Sheena asks, I was let go from a contract position with 8 months left on my original agreement. Am I owed any severance for this? So, Sheena, it sounds like you're on something called a fixed term contract. And if you're terminated during the term of that fixed term contract, then you are likely owed damages for the remaining time that's left on the contract after the point you have been terminated. And so it sounds like from what you're saying, there might be 8 months left, and you would be owed potentially 8 months of pay and potentially more as well, depending on whether you have worked for this company before how many times you've been placed on a fixed term contract. If it's the first time, it's very different than if you've been placed on a fixed term contract several times. That could be considered one indefinite term contract. So please contact us. You're likely owed compensation. It could be 8 months or more. So again, help@employmentlawyer.ca, and use that Pocket Employment Lawyer tool as well. Okay. Now, I have another topic that is a very, very hot topic as well. And that has to do with Shopify. So as some of you may know, there's a company called Shopify. They've laid off around 10% of their workforce. And the reasoning is that the company alleges that they were trying to transition into the e-commerce world. It was unsuccessful. And so as a result, they have to lay off 10% of their workforce. And they're offering the 10% of the individuals that they're laying off 16 weeks of severance pay, plus an additional week per year of service for each employee. And what's very important to note is this very well may not be enough severance pay for you. If you're one of those individuals who are laid off from Shopify and you're listening to this, or you are in a similar situation, definitely contact us, because depending on your particular circumstances, as I've mentioned throughout this session, you might be owed much more than 16 weeks of pay plus an additional week per year. And so please contact us. And I should add that while it might be unfortunate what is happening with Shopify, if they might be, suffering from a business perspective, you should focus on your own termination entitlements, because it's also unfortunate for you if you've been terminated or laid off from Shopify, or you're in a similar situation. So please contact us. Use our Pocket Employment Lawyer tool to figure out what you might be owed. And depending on whether there's an employment agreement in place, you might be owed significantly more than what Shopify is offering you. So please don't hesitate to reach out. It's very important that you do so. Okay, so we have another question from Gerald on Facebook. And Gerald asks, I work for an emergency services position in the US, but have been told I am not entitled to standard holidays in Ontario. Is this accurate and makes childcare very difficult? So, Gerald, I'm trying to glean what your particular situation is based on what you've told me. I might need more information. I'm not sure if you actually work for a US company or an Ontario-based company. If you work for an Ontario-based company, you are entitled to statutory holidays, so that will really depend on whether you work for an Ontario-based company or a US-based company, regardless of where you might actually be located. So I'm not sure if you're located in the US, where you reside, or in Ontario, but it will depend on if the company, if you're considered to be an employee in Ontario or not. I understand that might make childcare very difficult. And so please reach out to me or to anyone at our firm, and so we can help figure out what your situation is. You certainly might be entitled to your statutory holidays or to termination pay if there's been any substantial changes to your employment as a result of your situation. So Gerald, I hope that answers your question, and please contact us at help@employmentlawyer.ca. Okay, we have a question from Sam. Sam asks, I am in a sales position and have had my bonus percentage cut. Employer is claiming loss of business. It is part of my contract agreement. Is there anything I can do? So Sam, very likely there is something you can do. Depending on what that bonus percentage is, if it does form a part of your compensation pay, especially if it's part of your employment agreement, and if you've been paid bonuses in the past, that very likely might be a constructive dismissal of your employment, depending on the reduction of the bonus. So slight reductions might be permissible, but it's very likely that what your employer is doing is not legal, and so you should absolutely contact us. It sounds like there is a breach of your employment agreement, and we can help you out to get you the compensation that you deserve, or to help rectify your workplace situation in any way that we can. So I hope, Sam, that answers your question. Okay, I have a follow-up question from Archie. So Archie asks, are there changes to my contract my employer can make that I wouldn't have to sign off on first? So Archie, any changes to your contract is something that you have to agree to. You should not sign anything before you agree to it. And you should contact us immediately, because even if you don't sign any change to your employment agreement, but you actually fulfill the changes in some way, that could be considered a condonation. You could be considered condoning the changes to your employment situation. And that could be problematic as well. So before you sign anything, and before you condone any changes by way of any actions you might take, then you should definitely contact us, because you don't want to agree to anything that your employer is imposing on you before you have an employment lawyer review it. And so contact us at employmentlawyer.ca, email us at help@employmentlawyer.ca, and we can figure out whether this change is permissible or not, and what you should do about it, Archie. Okay. So those seem to be the questions that have come in today. Thank you very much for listening. I will be back hopefully soon, and I'll be able to answer more of your questions. I hope I answered your questions sufficiently, and that you feel satisfied. And I want you to contact us if you have any other questions at help@employmentlawyer.ca. As you see on the screen, we have another live session with Lior Samfiru at 1 p.m. On August 3rd, tomorrow, Wednesday, August 3rd. And so if you have any other questions, please join for that session, and we can answer your questions and get your workplace issues rectified. So thank you for joining us. Contact us at employmentlawyer.ca, email us at help@employmentlawyer.ca, check out that Pocket Employment Lawyer tool, and I hope you have a great day. Take care.